Very good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. This is our 11th lecture series, and we are getting good response from the members of the bar. And we are very happy to welcome each one of you. Today's topic for discussion is the appellate jurisdiction of the Supreme Court of India, more particularly on Article 132 of the Constitution of India. So how am I going to approach this topic? Before that, it is our routine practice that we recite the preamble of the Constitution of India before starting the session. So my humble request to each one of you is to recite the preamble along with me. Therefore, we can remember our forefathers and to what extent we can strive towards achieving those goals embedded in the Constitution of India. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. So this should be our everyday prayer, dear friends. Whatever they have stated in each word mentioned in the preamble, it is not a mere word. There is 200 years, 300 years history is behind those words. For example, if we say that to declare our India is a sovereign country, meaning thereby we are conveying a message to the entire world that we were ruled by the Britishers, by foreigners earlier. Now we are not dependent on anyone. We are independent. We can decide our internal affairs as well as external affairs, for which how many lives of the citizens of this country has lost, how much bloodshed, how many lawyers involved in the national freedom movement, and they have lost their practice, they have lost their family only to achieve that word that India is sovereign. So now the students or others also, they must understand the depth, meaning, root of each word mentioned in the preamble, and not only remembering that, whenever we try to draft a petition, for example, there was a very recent judgment by the Honorable Supreme Court with respect to challenge with respect to section 6A, very recent judgment, where they have referred to fraternity from the preamble of the Constitution of India. Yesterday we drafted a petition with respect to the habeas corpus, where we also refer to the fraternity, assuring the dignity of the individual. The destination, the goal is to achieve what is embedded in the preamble. So through which process, there are many constitutional provisions are there. There are many other statutes are there to achieve the goal, that is what is enshrined in the preamble. Therefore, how do we recite Janagana Mana, to recite, to praise our mother India? In this similar manner, if you want to recite this preamble, we can praise our legendary father, living father, dynamic father, that is our Constitution of India. Why do I say so? That Constitution of India is our father. The reason is, father is protecting our mother India, prescribing the union and its territories. Who are the citizens? What are their fundamental rights? What are the fundamental duties? So everything, the entire nation is functioning in consonance with the Constitution of India. So therefore it is a rule of law. We say it is a rule of law. Government may change within 5 years or even before the 5 years also, but this rule of law will continue forever. Rule of law is nothing but a rule of constitutional law. So when we are saying that constitutional law is a rule of law, where it is being administered, where it is being practiced, constitutional law, it is before the constitutional courts, where the High Court or the Supreme Court, where we are practicing as an advocates, we are practicing such highest courts. Therefore, we are assisting the Honorable Supreme Court or the Honorable High Court to uphold the rule of law. So, we are also the part of the system and we are also the rulers of law. We are trying to make, assisting the Honorable Court to uphold the rule of law. Therefore, we have highest responsibility, accountability, and sincerity should be there to bring those words in true sense. Therefore, we don't think that we are ordinary advocate. We do not know anything. We are juniors. We are just passed out. We are not having proper experience. There is no one to guide us. Don't have that feeling. Once you lift the Constitution of India, the Constitution of India will lift you. Once you start having the respect towards your profession, profession will also start respecting you. So therefore, dear friends, even I have come from down south, from Tamil Nadu. When I came to Delhi, I did not know ABC of Hindi. Now today I have the entire family sitting in front of me. It is all because of the education, the knowledge, the wisdom that we gain over a period of experience. Only thing is, what we must possess is the interest, passion for learning law. That is most important, and we must always realize our inner strength. Dr. APJ Abdul Kalam always says, when you are aiming for something big, that will make you big. You don't see how many attempts has to be made in the AOR examination. Don't see that there are 5 attempts. See to that there is single attempt, and we need to aspire for the gold medal. We can do for that. Just if you are thinking that you should pass only the examination, that is a sin that is being committed by you. You are underestimating yourself, that you have the potential to fly, but you are just walking, or not even walking, you are depending on someone, whether they will take us to the path. Therefore, dear friends, realize your inner strength. Having faith in oneself is most important. When you have faith in millions of gods, these are the words of Swami Vivekananda. When you are having the faith in millions of gods, and if you are not having faith in yourself, that means you are an atheist. You believe in yourself. That is most important. The history of the world is the history of few men who had faith in themselves. So therefore, dear friends, and we are standing here in the presence of Dr. B.R. Ambedkar. His spirit is always there. Look at his life. From the beginning, he had a very humble background, and he was interested to decide the destiny of this country by becoming a draftsman, chairperson of the drafting committee. He was the first law minister, right? So therefore, dear friends, we must always realize our inner strength and don't underestimate yourself, and open a book and then start reading. Definitely you will understand. Day by day you will understand your own progress. So with this positive note, let me move on to the topic for today, that is the appellate jurisdiction of the Honorable Supreme Court of India, Article 132. Now let me ask myself this question: how am I going to approach this topic? Right? We must know the headings by which we are going to approach this topic. So under Article 132 of the Constitution of India, first I will take you to the relevant provisions. The bare reading of Article 132 read with Article 134 capital A of the Constitution of India. So we will read the bare reading. Secondly, what are all important key words mentioned in those Article 132. For example, they say an appeal to the Supreme Court. From where? From the High Court. Against what? Against a judgment, against a degree, or against a final order. In what proceedings? In civil proceedings, criminal proceedings, or other proceedings. So, we are preferring an appeal to the Supreme Court from the judgment passed in a civil, criminal, or other proceedings, provided if a certificate is issued by the Honorable High Court under Article 134 Clause A of the Constitution of India. What is that certificate? Is there any prescribed form? Generally, when we say it is a certificate, there is a imagination creates in our mind, okay, this is to certify that so and so. It is not like that. There is one paragraph added in the order by saying that this is a case where it involves the question of law. Not only mere question of law, it involves substantial question of law as to the interpretation of the Constitution of India. It is not talking about interpretation as to IPC, CRPC, or any other provisions, PMLA. It talks about the interpretation as to the Constitution of India. So, two conditions should be fulfilled when the High Court is giving the certificate under Article 134 capital A, stating that one is substantial question of law involved as to the interpretation of the Constitution of India. So, this is what Article 132 is. Thereafter, I will be taking you to whether an appeal can lie to the Supreme Court from the High Court from a single judge or a division bench. Right? When we say Article 132, an appeal lie to the Supreme Court, from which bench? From the High Court we are saying. Is it a single bench or a division bench? What is the practice in the Honorable Supreme Court? Then when we say what are the civil, criminal, or other proceedings, so what is civil proceeding, what is criminal proceeding, what is other proceedings? Second, what is substantial question of law, who can file an appeal, what is the form of certificate, and scope of appeal before the Supreme Court under Article 132 Clause 3. So, we are going to dissect each and every words provided under Article 132. Let me ask this question, dear friends. What is the difference between a senior advocate and an advocate, not as per the Advocates Act 1961, but out of our experience? We are juniors or with the seniors, right, to have proper guidance. What is their approach towards the law? What is our approach being an intern or being a first 2 years old or 3 years old in the profession? When 50 years old also, the Constitution remains same. Constitution of India remains same to the designated senior advocates, to the AORs, to the advocates, or to the law students. But their approach, the law student seeing a particular provision, an advocate having 5 years experience seeing the provision, an advocate who has spent almost his lifetime seeing the having approach towards the Constitution is totally different. That is the difference it makes. So therefore, dear friends, what is the difference? According to me, in my humble opinion, the difference is, sometimes when we say we the people of India having solemnly resolved to constitute India into sovereign and so, we see it, sometimes we miss those words. But the designated senior advocates who has got knowledge and wisdom, who is expertise in the field of law, they see world in a particular word, entire world. What is sovereignty? They will take from UK, USA, Canada, and then coming to India and coming to a final conclusion, what is sovereignty. So they don't see it as a mere word. They will see a world behind the word. That is the difference. For example, Dronacharya had a favorite student called Mr. Arjun, right? How he is selected? When People were there, students were there. He asked to target a bird's eye, right? He wanted to target a bird. He asked, what you can see? Some of the students, they said, I could see sky, branches of a tree, and they could not focus on a bird's eye. So that was the difficulty. This is the difficulty being faced by now also. So what is to be focused? What are the material facts to be focused? Sometimes we make an argument which is supposed to be made at the very first instance. We make it as a lost argument. That is the where it makes a difference. So therefore, dear friends, we get that knowledge only over a period of experience and passion for interest. Today, everything is available in our digital world. Only thing is, we must take out our time. We must be focused. When we have always talk about doctrine of locus standi. When you have focus, then you can have locus in our legal profession. That is what the locus standi is. So have focus, but always mobile phones, other disturbances are always there, trying to push us down. So see to that you are awake consciously and don't get trapped and don't get derailed or deviated from the focus. When you have a focus, you will definitely have a locus to stand in this legal profession. Now let me take you to the bare reading of Article 132. Please, I would request each one of you, if you have the Constitution book or the provisions that you can download from the Google, Article 132. See, it falls under, if you say Article 132, it falls under Part 5 of the Constitution of India. Under Part 5 of the Constitution of India, it deals with the Chapter 1. Chapter 4 is the Union Judiciary, under which Article 124 of the Constitution of India speaks about the establishment of the Supreme Court. So once the Supreme Court of India is established, what are their jurisdictions? They are vested with various jurisdictions like original jurisdiction, appellate jurisdiction, advisory jurisdiction, review jurisdiction and plenary jurisdictions. So today our focus would be on appellate jurisdiction, that is more particularly under Article 132 of the Constitution. Let me read Article 132, dear friends. Appellate jurisdiction of Supreme Court in appeals from High Courts in certain cases. Clause 1. An appeal shall lie to the Supreme Court from any judgment, decree or final order of a High Court in the territory of India, whether in a civil, criminal or other proceeding, if the High Court certifies under Article 134 capital A that the case involves a substantial question of law as to the interpretation of this Constitution. So we would be seeing more particularly to the keywords provided under Article 132 Clause 1. Clause 2 is omitted. Clause 3 is where such certificate is given, any party in the case may appeal to the Supreme Court on the ground that any such question as aforesaid has been wrongly decided. There is an explanation also. There is an explanation given. For the purposes of this article, the expression final order includes, see, there is a final order used in clause 1, right? An appeal lie to the Supreme Court against the final order, judgment or decree. They have given the explanation what is final order means. Explanation: for the purposes of this article, the expression final order includes an order deciding an issue which, if decided in favor of the appellant, would be sufficient for the final disposal of the case. So this is what a bare reading of Article 132. Since they have referred to certificate under Article 134 capital A, it is my duty to take you to Article 134 capital A also. 134 capital A, certificate for appeal to the Supreme Court. Every High Court passing or making a judgment, degree, final order or sentence referred to in clause 1 of Article 132 or clause 1 of Article 133 or clause 1 of Article 134 may, if it deems fit so to do on its own motion, they can do it on their own motion by providing a certificate, and shall, if an oral application is made by or on behalf of the party aggrieved, immediately after the passing or making of such judgment, degree, final order or sentence, determine as soon as may be after such passing or making the question whether a certificate of the nature referred to in clause 1 of Article 132 or clause 1 of Article 133, or as the case may be, subclause C of clause 1 of Article 134 may be given in respect of that case. So, whenever a certificate is issued, it can be issued by the Honorable High Court on its own motion, or any party to the proceedings can make an oral application by saying that there are substantial question of law involved and it is to be heard by the Honorable Supreme Court because it involves interpretation as to the Constitution. So, based on the oral application made by a party to the proceedings, it cannot be done by a stranger. So, only when whether they have arrived as a petitioner or the respondent, they can make immediately after the passing of the judgment that please issue the certificate. So, that will also be recorded and that will be filed. In the civil appeal, we will file it. So, now we have seen what is a brief idea we know about Article 132 as well as 134 capital A. Now, I have suggested you how to see a world in a particular word, how to dissect, how to understand more in depth, so that we are going to see. So, this is, I am referring to a book that is a Supreme Court Practice and Procedure authored by senior advocates Raju Ramachandran and senior advocate Gaurav Agarwal. So, now they are taking us to what is any judgment or final order means. So, let us understand that particular term, what is judgment. Article 132 of the Constitution provides that an appeal shall lie to the Supreme Court from a judgment, degree or final order of the High Court. The words judgment, degree and final order have been discussed in various cases decided by the Privy Council and the Federal Court. The Supreme Court has broadly followed the test laid down by the Privy Council and the Federal Court in these matters. The Supreme Court in Asrumati Devi versus Kumar Rupendra Dev Roy Court discussed the test to determine the meaning of judgment under clause 15 of the Letter Patent Act of the Calcutta High Court. The court approved the dictum of Couch, Chief Justice in the Calcutta High Court decision of Justice of Peace for Calcutta versus Oriental Gas Company, wherein it was held that we think, now they are going to interpret the term judgment. What is the meaning of the judgment? We think that the judgment in clause 15 means a decision which affects the merits of the question between the parties by determining some right or liability. So, the judgment passed by the court, it must determine either the liability or the right of a party. It may be either final or preliminary or interlocutory. The difference between them being that a final judgment determines the whole cause or suit. So the final judgment determines the entire thing, there is nothing left out. But a preliminary or interlocutory judgment determines only a part of it, leaving other matters to be determined. The court, however, held that every judicial pronouncement on a right or liability of a party cannot be regarded as a judgment. This is a rider. Previously, what they have said, when the judgment is passed, which determines some right or liability of a party itself would amount to a judgment. But however, they say the court, however, held that every judicial pronouncement on a right or liability of a party cannot be regarded as a judgment. The judgment must be a final judgment which puts an end to the proceeding so far as the court dealing with the proceedings is concerned. So they have given two sort of interpretations. One interpretation to the judgment is it is finally decided, the rights or the liabilities is finally decided between the parties, that is the judgment. Yet another view with respect to the judgment is when it determines the rights and liabilities of a party partially also, it may also amount to a judgment. Therefore, good for lawyers, whoever approaches us, we can interpret in such a way to advance the substantial justice. The interpretation, now the interpretation of the word final order. We have seen the judgment, now we are moving on to the final order mentioned in our article 132 of the Constitution of India. The interpretation of the word final order came up for consideration before the federal court in Muhammad Amin Brothers Limited versus the Dominion of India, where the federal court laid down a clear test to determine whether an order is the final order or not. It was held. So what is the final order? The expression final order has been used in contradiction to what is known as interlocutory order. Interlocutory order, in other words, it's an interim order. On the other hand, there is a final order. So what is the test to determine whether it is a final order or a interlocutory order? The essential test for determining the finality of an order is whether the judgment or order finally disposed of the rights of the parties. The fact that the order decides an important and even a vital issue is by itself not material. If the decision on an issue puts an end to the suit, if the decision on an issue puts an end to the suit, the order will undoubtedly be a final one. But if the suit is left alive and has got to be tried in the ordinary way, no finality could attach to the order. For example, a tenant files a suit for permanent injunction against the landlord, a bare injunction. He files an interim application also for interim injunction against the landlord because he has paid the amount, advance amount, rent or the lease amount he has paid. So he should not be unnecessarily disturbed by using the muscle power or money power by the landlord. So therefore, a plaintiff files a suit for permanent injunction. Till the disposal of the suit, he seeks an interim injunction. So interim injunction is granted, injuncting the landlord from interfering with the possession of the property vested with the tenant. So it's an interlocutory order. Can we say it as a final order? The answer is no. Reason is many things used to be left out. It's only an interim order. They are protecting the right till the disposal of the suit. So therefore, even after this injunction order, there are many things, many issues are left out to be decided by the court. Whether is he a tenant, is he a landlord, and what are there, whether there was any lease agreement or rent agreement, whether was it paid periodically. So to get interlocutory order, you have to establish a prima facie case. You have to convince the court that you have got a good case, but good case may turn out to be the worst at the end of the suit if it is dismissed. So therefore, dear friends, interlocutory order means that other things are also yet to be decided, other issues are remain alive. Final order means nothing is left out. In ICU, patients are there remaining alive, something is left out, interlocutory. After thereafter, that's all, there is a final order passed by the my lords. So this is how we can understand. See, law is something, law is life. When we are traveling in a car, motor vehicle accident, motor vehicles act is applicable. When we are in a rented place, we are governed by the Rent Control Act. So everywhere law is governing us. What is law? Let us ask the simple question to a layman. To understand the meaning of law, I can give you one example how law is very, very important. Today, there is a road is there is a signals are there. Red light means stop, yellow means warning, and green means you can move. When there is no indication of any such lights, and people have to rush to the court or to many other places, offices, when nothing is there, then definitely nobody will reach their destination, because there is no regulation at all. So to have regulation towards the traffic rules, if red light is there means you stop, there is a green light for somebody to move on. So therefore law is something to regulate us, how to lead a peaceful life without disturbing others. You have a freedom to speak and expression also, freedom of speech and expression, but I cannot speak whatever I want. That should not hurt you. So it is subject to reasonable restrictions. So law is nothing but making us a disciplined person, making us regulating. Therefore there will not be any law and order problem, and people can lead a peaceful life. When you are earning and getting a property out of your hard earned money, how do you prove this is your property? You will produce by having a sale deed. Yes, I have a sale deed, I have got it registered. So that is a law protecting your ownership towards the property. Otherwise, even after having the ownership, we are having many difficulties. So therefore, dear friends, we must worship law, because law regulates, making us to lead in a peaceful way. When law is not there, we will go to the Stone Age only, where we used to pick up stones and bite each other, kill each other. So law is something, it regulates and disciplines and sets the order, law and order, in a peaceful manner. This is what the basic understanding of law is. Now let us move on to what is interlocutory order. Reason is whether a certificate can be issued for against the interlocutory order. A certificate granted by the High Court on an interlocutory order would be incompetent under this article. In Sardar Saidanath, there is a long case name is there versus State of Bombay. The Supreme Court held that certificate under Article 132 and 133 should not be granted in respect of an interlocutory order. So Article 132 says it's an appeal to the Supreme Court against judgment. Judgment means there are two interpretations. A judgment means anything to be decided partially also with respect to the rights and liabilities, that can also be considered as a judgment. In other interpretation to the judgment is it's a final judgment and nothing is left out. It decides a finally issue between the parties. What is final order and what is interlocutory order, we have seen it in detail. And whether a certificate can be issued even in interlocutory order, the answer is no. Now we are moving on to the next stage. we say an appeal to the Supreme Court, either from a High Court, whether is it from a single judge or a division bench, what is the law involved on this? That is the question. The proceeding under Article 132 are different from those under Article 133 Clause 3 of the Constitution. It is not necessary that the judgment, degree or final order should be that of a division bench. So what they are saying is, under Article 132, it is always not necessary that you have to prefer under 132 only from the order passed by division bench. It is not necessary. Whereas Article 133 Clause 3 restricts an appeal from the judgment, degree or final order of a single judge of a High Court. There is specific clauses there under Article 133 Clause 3, which specifically restricts an appeal from the judgment, degree or final order of a single judge of a High Court, but there is no such restriction in Article 132. Therefore, meaning thereby, even when it is a judgment passed by a single judge, you can straight away come to the Supreme Court after getting the certificate issued under Article 134 capital A of the Constitution of India. In a question covered by Article 132, an appeal lies directly to the Supreme Court from the decision of even one judge sitting singly if he gives the necessary certificate. The Supreme Court also held that the judgment of a single judge of the High Court can be carried in appeal to the Supreme Court if a certificate is granted. And Article 133 Clause 3 is no bar to such an application. The court in Election Commission India versus Saka Venkata Subba Rao stated that. So they have discussed in this case, Election Commission of India versus Saka Venkata Subba Rao, whether an appeal can lie before the Supreme Court from a single judge or a division bench. That was discussed in this case. So what was discussed, I am taking to the relevant portion. It is true that the constitutional questions could be raised in appeals filed without a certificate under Article 132. The terms of that article make it clear that an appeal is allowed from any judgment, degree or final order of a High Court, provided, of course, the requisite certificate is given and no restriction is placed on the right of appeal having reference to number of judges by whom judgment, degree or final order was passed. So they have not referred as if in Article 133 Clause 3 that only division bench judgment can appeal to the Supreme Court. Where do you find such provision in Article 132? There is no such provision. There is no such restriction. Therefore, a single judge passing a judgment against that, once certificate is issued, you can approach the Honorable Supreme Court. Had it been intended to exclude the right of appeal in the case of judgment etc. by one judge, it would have been easy to include a reference to Article 132 also in the opening words of Article 133 Clause 3 as in the immediately preceding clause. If the respondents' contentions were accepted, not only would Article 132 become redundant so far as it relates to civil proceedings, but the object of explanation to that article, which was designed to supersede the decision of the federal court in S. Kuppuswamy Rao versus King, and thus to secure a speedy determination of constitutional issues going to the root of a case, would be defeated as the explanation is not made applicable to the same expression final order used in Article 133 Clause 1. The whole scheme of the appellate jurisdiction of the Supreme Court clearly indicates that questions relating to the interpretation of the Constitution are placed in a special category, irrespective of the nature of the proceeding in which they may arise, and a right of appeal to the widest amplitude is allowed in cases involving such questions. So this is one way of interpretation, dear friends. As such, there is no such restriction found in Article 132. Therefore, the Honorable Supreme Court has held that even from a single judge, when certificate is issued, an appeal shall lie to the Supreme Court. However, there is yet another way or approach. Though a single judge of the High Court can grant a certificate under Article 132, Clause 1 of the Constitution, this practice has been appreciated. Sorry, this practice has not been appreciated by the Supreme Court. In R.D. Agarwala versus Union of India, the court observed, this is yet another view of the Honorable Supreme Court. What the Honorable Supreme Court has held in R.D. Agarwala versus Union of India, the court observed the practice of deciding the case sitting singly and giving a certificate under Article 132, Clause 1 for appeal to this court, although technically correct, is an improper practice. Is technically correct, but it is an improper practice. It is the right of the party to file an appeal in the High Court itself against the decision of a single judge, and that the right should not be short circuited by passing on the case to the Supreme Court for decision. So the position is, what is the conclusion now? The position emerging from these cases is that a single judge should, as far as possible, avoid granting certificates under Article 132, Clause 1 unless there are some very exceptional circumstances. The Supreme Court has further held that a certificate cannot be granted when there is a difference of opinion between two judges of the High Court. The matter to be final must be referred to a third judge. From reading of these, appeal lie, the question before us is, when we say it is an appeal lie before the Supreme Court from the judgment passed by the High Court, whether judgment passed by a High Court, whether a single judge or a division bench, how to have an approach? The answer is, there is no any such restriction at all provided under Article 132, that they have not mentioned that the decision of a High Court has to be only by a division bench. They have not prescribed any number of judges, whether division bench or a single bench. So therefore, meaning thereby, always when there is an order or judgment, final order passed by the High Court, when they give a certificate under Article 134 capital A, that is sufficient to approach the Honorable Supreme Court. But there is a rider to it. Generally, the Honorable Supreme Court has not appreciated, though they may be technically correct. For example, when we file a petition, a writ petition under Article 32 of the Constitution of India, seeking mandamus or other writs, it is considered to be Article 32 is itself a fundamental right. According to Dr. B.R. Ambedkar, he has said it is a heart and the very soul of the Constitution of India. But when we file Article 32 petition before the Honorable Supreme Court, the first and foremost question put forth by the Honorable Supreme Court to the learned counsels, did you approach the High Court? What prevented you from approaching the High Court? Why do you come directly to the Supreme Court? Though you have a fundamental right, but have you exhausted your alternative remedy? So those are the questions staring at the face of the learned advocates. I have seen in many of the cases where Article 32 is filed, withdrawn, liberty to approach the High Court. Then after the High Court order is passed, they come to Supreme Court under 136. Likewise, here under Article 132, though the judgment passed by a single judge can be, an appeal can be preferred before the Supreme Court, but however that practice is not appreciated by the Honorable Supreme Court. Why have you not gone to the division bench? So you should approach the division bench. There is a reason behind this. The reason is, when there is a fault, when we find a fault with a single judge, there is one more scope that we get to be rectified by the division bench. Thereafter, you have yet another remedy to the Supreme Court. So therefore, instead of exhausting two remedies, why do you come directly to the Supreme Court? Even the honorable judges, while dismissing the writ petitions, and giving liberty to the advocates to approach the High Court, what they say is, we will at least have a constitutional court look into the issue and come out with some judgments. Why should we take right now? Let the High Court, Constitutional Court, let it go into the issue, and then let there be a judgment, and then we will see whether that judgment is right or wrong. Why do you approach directly to us? So that is how the honorable judges entrust the matter to the constitutional courts. So here, though there is no any such restrictions, but generally it is advised that a person can approach the division bench and then come to the Supreme Court. Even yet another illustration is Article 136, special leave petition. 80% of the cases are filed in Supreme Court through special leave petitions. The Supreme Court in its discretion may grant leave to appeal against any order. It is wider, be it final or be it interim, any order directly to the Supreme Court. But can we file a case, any order against any order passed by any district courts directly to the Supreme Court? The first and foremost question is, what is the exceptional circumstances by which you are knocking the doors of the Supreme Court? Show us the exceptional circumstances. Where is the grave miscarriage of justice? Show us. My lords, there is nothing. Then why don't you go to Appellate Court? Why don't you go to High Court? Why do you come directly to us? So therefore, what is there in law, but in practice, it's something different. And we must appreciate that also. Now moving on to the next question. We have seen an appeal laid to the Supreme Court against any judgment, order, degree. In what proceedings? In civil, criminal, or other proceedings. So those words, we are going to see the world behind those words, how it has been interpreted by the honorable judges. Article 132 envisages appeals in 3 categories of proceedings. Number 1, civil. Number 2, criminal. And number 3, other proceedings. Whereas according to American law, a proceeding that is not criminal must be civil. It is not so according to our constitution, because it may not be civil as well. Moreover, it cannot be assumed that the words civil and criminal proceedings have established meaning, and that what is a civil proceeding in one country is a civil proceeding in another. Ordinarily, now let us have an ordinary understanding about the meaning of civil proceedings. Ordinarily, civil proceedings means, or those proceedings relating to right to property, status of person, or right to an office. I repeat, civil proceedings or proceedings relating to right to property, status of person, or right to an office. Proceedings mean, in the ordinary sense, the form in which action is brought or defended. So today we had a case before the Honorable Supreme Court, a transfer petition came up before a single judge. It's a transfer petition, civil. So therefore it is a civil proceeding, because we have invoked the civil jurisdiction of the Honorable Supreme Court. If you file a writ petition, criminal, writ of habeas corpus, you are invoking a writ jurisdiction related to the criminal proceedings. So how are you approaching? You are invoking such jurisdiction of the Supreme Court. Supreme Court is having ample power, but through which way we are invoking the jurisdictions, that is important. So the simplest definition of civil proceeding is a proceeding in a court of civil jurisdiction. The words jurisdiction and proceedings are interchangeable. The code of civil procedure is meant to govern the procedure in a civil courts, but its applicability is not the test of a civil proceeding. You cannot say CPC applies to a court, therefore it becomes a civil court. That is not the test. The applicability of civil proceedings, the applicability of civil procedure is not the test, because it may be applied even to the revenue and other proceedings also. The Supreme Court had occasion to discuss what is meant by civil and criminal proceedings. The Supreme Court had occasion to discuss what is meant by civil and criminal proceedings. In his order dated 16th of December 1962, they are referring to an order dated 16th of December 1962. Honorable Mr. Justice J.C. Shaw agreed with the order of the learned Deputy Registrar. So there was an order passed by the learned Deputy Registrar that was challenged before the Supreme Court. Supreme Court confirmed the order of the Deputy Registrar. What did Deputy Registrar said? Registrar and has upheld his classification of civil and criminal proceedings. So the learned Deputy Registrar had an occasion to classify, to explain, to elaborate what is civil and criminal proceedings. It has been held that the words criminal proceedings must involve the consideration of some charge of crime, that is, of an offence against the public law, and that charge must have been or about to be preferred before some court or judicial tribunal having or claiming jurisdiction to impose punishment for the offence or alleged offence. Such a proceeding will be a criminal proceeding. If carried to its conclusion, it might result in imprisonment or fine or imposition of punishment for some offence. A criminal proceeding includes all such proceedings which, carried to its logical conclusion, will result necessarily in punishment of the person concerned. So there must be an offence followed by a punishment, and such offence is always considered to be against the public at large. The distinction was discussed in detail. S.A.L. Narayan Rao versus Ishwar Lal Bhawan Das. The court held. So the court held between what is civil proceeding and the criminal proceeding. The expression civil proceeding is not defined in the Constitution nor in the General Clauses Act. The expression in our judgment covers all proceedings in which a party asserts the existence of a civil right conferred by a civil law or by statute and claims relief for breach thereof. So you must have a right provided by a statute, and you approach for such breach and get a remedy. So where there is a right, there is a remedy. Ubi remedium. As far as criminal proceedings are concerned, on the other hand, is ordinarily in one which, if carried to its conclusion, it may result in the imposition of sentence such as death, imprisonment, fine, or forfeiture of property. It also includes proceedings in which, in the larger interest of the state, orders to prevent apprehended breach of the peace and order, or orders to bind down persons who are a danger to the maintenance of peace and order, or orders aimed at preventing vagrancy are contemplated to be passed. But the whole area of proceedings which reach the high courts is not exhausted by classifying the proceedings as civil and criminal. So the simple understanding of civil and criminal proceedings is civil proceedings where it defines or consents with the right to the property, or where the civil law is applied and there is you are getting a right under a statute and you are approaching the civil court for its breach and then getting a remedy. That is civil proceedings. With respect to the criminal proceedings, there must be a charge against an accused, there must be some element of offence involved, and he is being tried, and then there is consequences, that is, you are sentenced to death or imprisonment for life or fine or forfeiture of property. So that is the criminal proceedings. What about the expression other proceedings? The expression other proceeding thus seems to envisage the existence of certain types of proceeding which may be regarded to be neither civil nor criminal. The words other proceedings were not included in section 205 clause 1 of the Government of India Act 1935, and in that respect article 132 is wider than the said section. These are words of even wider amplitude and include all proceedings other than civil and criminal proceedings, and also include revenue proceedings. So therefore, dear friends, we have seen how the appeal lies against a single judge or a division bench. We have seen what is civil, what is criminal and other proceedings. Now we have reached the heart and soul of the seminar today. And every time we listen to this term in our corridors as well as inside the courtrooms also. Substantial questions of law. Substantial questions of law. What is the substantial question of law involved in your case? Tell us, counsel. That is how the judges pose the question to us. Let us dissect and let us understand what is substantial question of law means. Question means, let us understand in common parlance, layman's approach. Question. They are asking a question. With respect to what? With respect to the law. Question of law. Whether such question arises out of the law, a particular law, maybe, for example, let us take, I will give you an example also. Whether right to privacy is a fundamental right or not. We do not find from bare reading of Article 21. The question came up before the Honorable Supreme Court. Whether right to privacy, it is not provided anywhere in the Constitution. Therefore, we don't have any fundamental right. That was the contention put forth. But the answer is, it is a natural right. Right to privacy is a natural right. Therefore, it should be read into Article 21. Article 21 will reflect the scope is wide as that of the sky. Right against handcuff, right to speedy trial, right to water, right to clean environment, right against forced labor. So everything, what not? Article 21 provides us everything. So when there is a question as to the interpretation of the Constitution, is it substantial or not? Is it a simple question? Or is it a meaningless question? Or it concerns the public at large? If it is a substantial question, it means it must have a huge impact. When such area has to be decided by the court, we need a settled principle of law with respect to the interpretation of that particular provision. So question of law means, a substantial question of law means a question arising out of the law, that is more particularly under Article 21, whether right to privacy is implicit in Article 21 or not. Whether is it a simple question or a substantial question? Definitely it concerns each individual. So therefore it is a substantial question. It decides the rights of the parties, rights of the citizens. So any question arising out of the law with respect to the concerning the public at large, it becomes a substantial question of law. That law means what? Is it a constitutional law alone? Generally, I am talking about, it may be any law, any statute. So whenever you file a case before the Honorable Supreme Court under Article 136, always don't start preparing a case with a negative note, dear friends. Because sometimes we as an advocate, when there are concurrent findings by the Honorable High Courts and the courts below, or three courts against us, then we generally what we will think? We will start with a negative note. 3 courts have held against you. What should we do? We will file it just to satisfy the interest of the client. Let us see. Generally, we are going to get a dismissal order. That is how the approach is, general approach. But you should ask yourself, this is a test for you to show your competence, to show your potential, how to bring a life out of a dead case. When there is no scope, provide the scope. That is where you play an active role as an advocate. So don't always start with the negative note. Start with the positive note. If everybody, all doctors have said that you don't have, you are a useless fellow, or there is no medicine to help you out, then if one doctor says, I will save his life, he becomes a hero. So when the opportunity comes to you to make you a hero, why do you want to remain as a zero? That is the question that we must ask ourselves. When everybody has left a hopeless case, you have a hope in you. You bring life to that particular case. That is most important. So anything, because everything is, there are merits and demerits. We cannot have 100% in our favor. Or there cannot be any 100% case against you. So what you want to see, you can see. What is to be projected, you can project. Only thing is, we should not have the competence, only that good intention we require. What is the best relief that I can provide to my client? It is not only a best relief to my client, but also my life is involved. My career is involved. My face value is involved. Therefore, what sort of contribution I can bring to the life of a client is implicit. The life of an advocate is also involved in that case. If you are going to consider each case is your life, then you are bound to succeed in this legal profession, dear friends. We will all grow together, think together, and see to that we, the people of India, must be happy, must be eternally happy. And what is our contribution towards it? We should ask ourselves the question every day. Now, having said what is the substantial question of law, what the Honorable Supreme Court has held, let me take you to what the Lordships has said. Substantial question of law means that the question involved must be one of law. They have simplified it. See how they have explained it in very simple manner. They are saying what is substantial question of law, that is the question. They are giving the answer. Number 1, the question involved must be one of law. Number 2, it must be a substantial question. The question of law to be substantial must be one in regard to which there is difference of opinion between different high courts. The proper test for determining whether a question of law raised in the case is substantial would, in our opinion, be whether it is of general public importance, whether it is directly and substantially affects the rights of the parties. If so, whether it is either an open question in the sense that is not finally settled by this court or by the Privy Council or by the federal court, or is not free from difficulty or calls for discussion or alternative views. For example, when there is already a law settled by the Honorable Supreme Court, if you have alternative view to that, that is how 2 judges bench is being considered by full bench, 3 judges bench. 3 bench judgment is being considered by 5 judges, 7 judges. Always you can have, for example, a dissenting opinion where majority opinion is there. There may be one judge giving a dissenting opinion. You may ask us, sir, majority of the judgment will hold the law. Then what is the purpose of giving a dissenting opinion? One is freedom of speech and expression. What do I think? What do I feel that what is right, what is wrong? I have the right to say. Therefore, dissenting opinion. At one point of time, maybe after 10 years, after 15 years, that dissenting judgment may become a judgment, may hold the field in law. So therefore, whenever there is some settled principles of law also, to what extent we can take it forward. See, in thesis, I have done my doctorate in law. They have said in the college, in the university, they have taught us. They asked me, what do you want to select? The topic for thesis to be selected. I said, I will select the judicial delay. That is the topic. Then my Professor Dr. Shantakumar sir, he was the director in National Gujarat University, Law University. At that time, he was a pro VC at GD Goenka University. He told me, judicial delay means what? Where? Judicial delay in district courts, judicial delay in high courts, or judicial delay in Supreme Court? Where do you want? Then I said, Professor, since I'm practicing in Supreme Court, let me take Supreme Court, judicial delay. Then he asked me yet another question. Judicial delay with respect to civil cases or criminal cases? Which case? Then I said, so could you please suggest what is to be done? Then professor suggested me, if you want to select some topic, you have to get focused on only one article or only one section, particular section. You have to see that particular section is blown up and you make the entire thesis from one provision. Then I took article 136, that is special leave petitions, docket explosion of special leave petitions leading to the judicial delay. So what I've learned from my professor is, from single word, how do you take it and how do you see the entire world in a single word? That is most important. That is what the thesis is. And I was told there are already theses made on judicial delay. So what is my contribution? Your contribution is, for example, a person who has traveled from 1 to 50 kilometers. There are other kilometers also available, distance is there. So you start from 50 first and take to 100. And then your fellow research will come and they will take it further research. That is how they make the thesis. So the message is, there is no stop to our knowledge and wisdom. Knowledge and wisdom is depth, as that of depth in ocean. Can we measure the depth in ocean? Therefore, even if we can do so, but depth in knowledge we cannot do so. That much knowledge. That is what Saint Thiruvalluvar, he has discussed about Thirukural. He has written a book called Thirukural. Saint has touched upon all the topics, how a student has to be, how a teacher has to be, how a husband has to be, how a ruler has to be, how a judge has to be. He said, in Tamil I will say, and I will translate it in English also. Tottani thoorum manarkeni, mandarku kattani thoorum arivu. Which means, when a person wants to dig a well, to what extent he digs, to that much extent he will get a water. So how much knowledge, how much you read, that much knowledge you will gain. Knowledge converted into money, knowledge converted into service, knowledge converted into your face value, everything. So when there is a Saraswati with us, we will have a hope Lakshmi will follow us. So with this, let me take few questions. Yes. So dear friends, almost we have completed. So we have seen what is, let me sum up dear friends quickly. Article 132 of the Constitution of India, it is an appellate jurisdiction where it is a matter of right we can approach the Honorable Supreme Court. It's a civil appeal. It is not like Article 136 where we are seeking leave from the Honorable Supreme Court. We are seeking the permission, grant leave to appeal against. That is different. That is that discretionary power. But it is a matter of right. So therefore, any appeal may lie to the Supreme Court against the judgment, decree or final order passed by the High Court in civil, criminal or other proceedings, provided a certificate is issued by the High Court under Article 134 capital A, certifying what? That if the case involves a substantial question of law as to the interpretation of the Constitution. And we have seen the discussions about what is judgment, what is final order, then who can, whether is it an appeal against the single judge or a division bench, what is civil proceeding, what is criminal proceeding, what is other proceedings. So therefore, we have seen to the best of our ability. So I wish you all the best, dear friends. Go through the question papers also and prepare yourself for the examination. Always aim for something big that will make you big. Thank you so much for your patience hearing. Thank you so much.